Thank you to everybody for joining us for our joint AF Chicago and AF Grand Rapids event. My name is Eric Cohn. I am the chapter leader of the Chicago chapter.
My name is Tyler Grunendahl, and I'm the chapter leader for the Grand Rapids chapter.
And we're really thrilled for everybody who's able to join us for part 2 in AF's ongoing monthly series on criminal justice reform topics. This one is, of course, on qualified immunity, and we are really thrilled to be able to bring you tonight Clark Neily. Clark is Vice President for Criminal Justice at the Cato Institute, where he focuses on constitutional law, overcriminalization, civil forfeiture, police accountability, and gun rights. He's the author of Terms of Engagement, How Our Court Should Enforce the Constitution's Promise of Limited Government. I heard Clark speak on that book a few years ago at the Illinois Policy Institute. It was a fantastic talk. I encourage everyone to check out a copy of that. Before joining Cato in 2017, Clark was the senior attorney and constitutional litigator at the Institute for Justice and director of the Institute's Center for Judicial Engagement. Also an adjunct professor at George Mason University's Antonin Scalia Law School, where he teaches constitutional litigation and public interest law. And he served as co-counsel in District of Columbia v. Heller, the historic case in which the Supreme Court held for the first time that the Second Amendment protects an individual right to own a gun for self-defense. Clark, thank you so much for joining us. We really appreciate it.
Oh, it's my pleasure. Thanks so much for having me on.
So why don't we start this way? We've heard a lot about qualified immunity in the wake of the killing of George Floyd, but it really was not a topic that was on a lot of people's radar prior to all of that. So yes, not really on a lot of people's radar prior to what happened with George Floyd. So why don't we start at the very basics? What is qualified immunity and how did it come to be?
Yeah, great. Thanks so much for the opportunity to talk about this. It's such an important topic. I really think actually this is one of the 2 or 3 most important pathologies within our deeply dysfunctional criminal justice system. And if I just had to put it in a nutshell, and I will unpack this in a moment, but the thing to know about qualified immunity is that it is the cornerstone of our near zero accountability policy for law enforcement. And believe it or not, at Cato, when I first took over the criminal justice program, we had a good-natured debate that went on for a couple of weeks about whether the most accurate way to characterize our criminal justice system is one of zero accountability or near zero accountability for law enforcement. I was finally persuaded that if you're going to be absolutely precise, you have to say it's near zero accountability, because every once in a great while, there's a tiny little bit of accountability that filters in. And let's start with that George Floyd case, because that's a very powerful context in which to illustrate the role that qualified immunity plays in our system. I assume everybody knows that the police officer who killed George Floyd, Derek Chauvin, by jamming his knee into George Floyd's neck while he was lying on the ground unresisting and handcuffed for more than 9 minutes, has been prosecuted criminally. He's actually been charged with second-degree murder. I think there's a very good chance he'll be convicted for a variety of reasons I don't need to get into, but if you've seen the videotape, you know what he did. The thing that's so incredible about qualified immunity is that if George Floyd's family sues that police officer, Derek Chauvin, in civil court, they will have, they would invoke a federal civil rights law that we refer to generically as Section 1983, because that's where it appears in the US Code. And what Section 1983 provides, and it has been on the books for more than 150 years in essentially unchanged form, is the following. Any state actor, that means any government official who is employed by a state or city, shall be liable to the person injured for the deprivation of any right. Once again, it's going to be very important, so I'm going to repeat it. Any state actor shall be liable to the person injured for the deprivation of any right. Here's the astonishing thing about the role that qualified immunity plays in our civil accountability system and the ability of people to bring a civil rights lawsuit. The police officer who killed George Floyd could be convicted of murder and yet still be immune from civil lawsuits. Why? Because of qualified immunity. Because qualified immunity protects police officers who have violated people's rights by making it virtually impossible to sue them. in civil court. And here's why that's so important. When you clothe government officials with extraordinary discretion and authority and power, the way we do with police officers, including even the power to take away somebody's freedom or their life, it matters tremendously how much accountability comes with that. And given the amount of power that police officers wield, you might think that they would be held to a very high level of accountability compared to the rest of us. But the truth is that compared to the rest of us, they're held to a very low level of accountability, far lower than the level of accountability that you or I would be held to under similar circumstances. And here's how it works. There are basically three ways that you could hold a police officer accountable for abusing their authority. The first is a criminal prosecution, which is what we're seeing in Minneapolis with the police who killed George Floyd. There are a number of problems with trying to use criminal prosecutions as a sort of a primary form of police accountability. The first is that not all police misconduct is a criminal offense, but the even more significant problem is that in order to bring criminal charges against a police officer, you have to find a prosecutor who's willing to do it. And almost none of them are. Why? Because they have a massive conflict of interest. They work with police, they socialize with police, they depend on police to bring them cases, and they depend on police to testify in their cases. And you will almost never see a prosecutor bring criminal charges against a police officer unless the incident in question has been caught on video that has gone viral, the exact way that it did in the George Floyd case, to the point where the prosecutor in question correctly perceives that the failure to do anything about it might represent a threat to their political future. That's basically the only time you'll see a prosecutor bringing charges against a police officer. The second potential avenue of accountability is internal accountability mechanisms, police policing themselves. And just to describe it is to explain why it doesn't work. We're talking about internal affairs, we're talking about citizen review boards, things like that. The basic problem there is that you have to persuade the police to find that the police have done something wrong, and they almost never do. I joke around sometimes that it's a bit like trying to persuade the fox that there's something has gone wrong with his protection of the hen house. Just doesn't happen. That's why the ability to bring a civil lawsuit against a police officer or other government official who you believe has violated your rights is so incredibly important, because it is the only accountability mechanism that can be initiated by the citizen who believes that their rights have been violated. The other two, you have to persuade some government official to initiate a procedure. With civil lawsuits, you can do it yourself. You can be the one who initiates the process, and you can be the one that sees it through. And what qualified immunity provides is that instead of the language chosen by Congress in 1871, when they enacted what we now call Section 1983, again, the language there is any state actor shall be liable to the person injured for the deprivation of any rights. The Supreme Court invented out of whole cloth this qualified immunity doctrine, and here's what it does. It inserts two words into that statute effectively. And what it does is it puts the words clearly established between the words any and right. So now you can't sue a police officer for the deprivation of any right. You can only sue a police officer for the deprivation of any clearly established right. And that clearly established language was invented by the Supreme Court out of whole cloth, like I said. And here's how it's been interpreted by the Supreme Court and the lower courts. In order to bring a civil lawsuit against a police officer or other government official, you have to identify a case in the relevant jurisdiction where the exact same thing that was done to you was done to somebody else, who then sued and got a ruling from the courts that said that specific thing is impermissible. It is a violation of somebody's rights. And if the thing that was done to you has never been done before, or has never been the subject of a lawsuit before, so that there was no court ruling, your case will be thrown out of court. Why? Not because your rights weren't violated. In fact, there are plenty of cases where all of the judges will say, oh yeah, your rights were violated, but we don't have a case exactly on point. So even though this police officer violated your rights, and we all agree that he did, we are still going to dismiss this case on qualified immunity grounds because we didn't have a case already on the books that told police that this exact thing that they did to you is impermissible. And I can give you some horrific examples of just how the way in which courts apply this to literally require almost identical facts before you can go forward. And so what qualified immunity does in our system is it prevents accountability by ensuring that police who have violated people's rights cannot be held civilly liable for doing so unless you can find a case already on point in that jurisdiction. And I'll finish by saying this. It has this extraordinarily perverse result that the more outrageous the conduct, the more likely the police officer is to get away with it. Because why? Because it's unlikely that it's happened before. Good luck finding a case in Minnesota where a police officer kneeled on somebody's neck for 9 minutes until they lost consciousness and ultimately died. I'm not saying that's never happened before, but I'll bet you're not going to find a case exactly on point. And if you can't find a case exactly on point, qualified immunity applies and your case will get thrown out. That is the state of accountability in American criminal justice today, and it is a travesty.
Thank you so much for that incredibly thorough overview. I learned a lot just from that short overview. I was wondering if you could comment briefly on what might be the first tri-partisan bill going through Congress right now about ending qualified immunity, co-sponsored by Grand Rapids' own representative, the first Libertarian Congressman, Justin Amash.
Yeah, it's a fantastic bill that Representative Amash introduced. We had some input. He reached out to Cato to get our thoughts about how best to take on qualified immunity, and I'm incredibly gratified to say that his bill is just about as good as a bill can be. It represents a complete repeal of this judicially invented doctrine of qualified immunity, and let me just quickly say why that's not as concerning as the law enforcement community would have us believe. It is not the case that once you eliminate qualified immunity, suddenly, police are going to be inundated with lawsuits every time, they touch somebody or every time they search a car or anything like that. That's just not true. Because keep in mind, if somebody alleges or tries to bring a lawsuit against a police officer and alleges facts that do not amount to a violation, you don't need qualified immunity. That case gets thrown out because there was no violation. And second, even if it's a close call, even if, there's a lot of stuff I recognize that comes up in the gray area, the absence of qualified immunity does not translate into some kind of strict liability where, if a police officer makes a close call and it's a gray area, some people could see it one way, some people could see it another. It is not the case that without qualified immunity, police are going to be held strictly liable for everything they do. Instead, what it means is that a jury will get to decide whether the police officer behaved reasonably or unreasonably. And if the police officer behaved reasonably and can explain, listen, I know it was a close call, but here's why I did what I did. And if you were in my shoes, you probably would have done the same thing. That police officer is not going to be held liable. The police officers who are going to be held liable are going to be the ones who cannot explain, cannot contextualize, cannot convey to a jury of 12 people why the thing they did was reasonable under the circumstances. And believe it or not, juries remain incredibly pro-police. So there will still be significant hurdles to somebody who wants to hold a police officer liable for the alleged rights violation. Qualified immunity simply takes that up another dozen or so notches to where perfectly meritorious cases are routinely getting thrown out of court. Again, not because there was no rights violation, but just because of the mere happenstance that the particular rights violation that happened in that case hasn't already happened before, to the point where a court stepped in and said, you're not allowed to do that. So it's an incredibly pernicious defense, and all credit to Representative Amash for taking the lead on this issue and being the first member of Congress to introduce a bill that would completely repeal this judge-made doctrine that never had any business being a part of our law and needs to be gone sooner than later.
Clark, something I'm curious about. So the way that you described, obviously there's plenty of judge-made law that exists out there. Qualified immunity is not the only example of judge-made law. Right. But the particular way that you described it functioning, where there has to be a specific case on the books that, is a clear precedent for what you are suing about. Is there anything else like that out there? Is this truly unique in the sense that it's one of the only areas or the only area where you have to find exact precedent? And has there been recognition within the legal community or within on the bench of what to, me as I'm not a lawyer and I don't even play one on TV, doesn't seem to make any sense that, like, if there's not a clear precedent for something, you can't sue for it. Well, how do you establish precedents if you can't sue and establish new law. To me, it seems completely baffling. So if you could address any of those points.
So I think it is completely baffling in what I might call the real world. But if you were to step into the constitutional world, or maybe I should say the world of constitutional law, to be more precise, what you would find, as I tried to sort of describe in the book that I wrote that you mentioned earlier, called Terms of Engagement, is that the world of American constitutional law, it was one of relentlessly government-favoring judges bending over backwards to find ways to rationalize and defend almost anything the government does. Every once in a while, you'll see a case where the government says, oh, you limited that person's speech, or you interfered in their free exercise of religion. And we tend to notice those cases. But that's a mistake. What you really need to realize is that the almost the dark matter of American constitutional law, in other words, the vast substance that's difficult to observe, but really represents the vast majority of what's going on in the system, is judges relentlessly finding ways to rule in favor of the government, expand government authority, and diminish their own role in enforcing constitutional limits on government. And I would say that the qualified immunity doctrine represents almost like this kind of perfect diamond of judicial government favoring. So it's exceptional in that it is so extraordinarily, blatantly government favoring, but it's important to realize that it exists against this larger backdrop of an institution, the judiciary, that is relentlessly government favoring. And I would say in large measure, probably because the federal judiciary is comprised disproportionately of judges whose prior professional experience was representing government in court. We did a study at the Cato Institute that you can Google, just Google judicial professional backgrounds. 44% of federal judges spent their formative professional years advocating for government, either as prosecutors or in some other role where they represented the government in court, whereas only 6% of the federal judiciary had their formative professional experiences either defending individuals in criminal cases or doing what I did at the Institute for Justice, representing individuals in civil cases against the government. So that's quite an imbalance, and I think it's perhaps no surprise that the federal judiciary would be an institution that is as relentlessly government favoring as it is. So qualified immunity may look kind of baffling in sort of the context of the normal world, but within the context of constitutional law, which is largely sort of formed by judges, it's actually not that out of line. I want to say one more thing. Not all judges fall into this relentlessly government favoring trap. And my good friend, Don Willett, who's a judge on the Fifth Circuit Court of Appeals down in Texas, has repeatedly criticized qualified immunity on exactly the grounds that you put your finger on a moment ago, namely that when you have a doctrine that enables judges to just skip over the question of whether a constitutional violation happened at all and simply go to the question of, well, putting aside whether the thing that happened to you violated the Constitution, was it clearly established? And they are allowed to go to that second step right off the bat. Then what happens? Constitutional law essentially freezes. You don't get a development of the doctrine. You don't get rulings on these cases. And he actually said this in a wonderful dissenting opinion where he said, what this means is that when a cop violates your rights on day one, and a judge says, well, that might have been a rights violation, I'm not saying, but I am going to throw the case out because it wasn't clearly established, that same cop can do the exact same thing to you on day 2, 3, 4, 5 ad infinitum. And you're exactly right that that's a real perversity within the doctrine. And let me leave you with this. Think about an institution. What does it tell you about an institution that would leave such a glaring perversity in the law, such an absolute pathology, and the Supreme Court knows about it, they know how it works, and they have stood by and done nothing about qualified immunity in general and that particular aspect of qualified immunity? Ask yourself what it tells you about that institution.
So like Eric, I'm far from an expert in constitutional law or the legal structure. Suppose this bill to end qualified immunity makes it through Congress and is passed successfully, signed, whatever. Is there anything on a state level, whether through state courts or state legislature rules, that could put something like qualified immunity on the books on a state-by-state level, or
Yes.
just eliminate the problem?
Yeah, they could. Now, the problem is, so let me be clear about one thing. The ability to hold police accountable is something that is a policy issue that operates both at the level of federal law, which is Section 1983. That's what I mentioned before. That is a congressionally enacted statute that gives you a cause of action to sue a state or local government official. So that's something the federal government created, an avenue of accountability in federal court. It is also the case, as you suggest, that in theory, a state government could provide you with a state level mechanism of accountability, and some of them do. Here's the problem, though. First problem is that some states have embraced or adopted this doctrine of qualified immunity at the state level, so that's a problem. But other states have found all kinds of ways to build hoops and hurdles into their various accountability avenues, so that even if it looks like on paper, oh, you should be able to sue that police officer in state court for the thing that he did to you, what you'll find is if you actually start digging in and reading the law, talking to people who work in this area, what you'll find out is that it's actually extraordinarily difficult in most states to pursue these kind of on paper remedies that you would read the actual law and say, well, that looks pretty straightforward. It turns out not to be straightforward at all. And this is no accident, because it turns out that the law enforcement lobby, if we kind of lump police, prosecutors, and prison guards into the same basic lobby because they're all fighting for the same thing more often than not, turns out that the law enforcement lobby is probably the second or third strongest in the entire country. They are an incredibly powerful interest group. They have a very focused set of priorities, and they throw amazing weight in both state legislatures and the US Congress. And so when you find yourself asking, like, why is it so hard to hold these people accountable? The answer is because they are so politically effective. They again, one of the strongest public interest or private interest groups in the country, a very strong political lobby. And I would say that they have no other issue that they have to which they assign a higher priority than ensuring that they are held to absolutely the lowest standard of accountability that they can get away with.
So it's been quite a week for the Supreme Court. Some pretty major decisions handed down this week, something that may have flowed under the radar of the Bostock decision and the decision today on President Trump's attempt to repeal Obama's executive order on DACA, was that the court decided not to grant cert on several cases pertaining to qualified immunity. And what I know from listening to some very smart lawyer types that I listened to is there was something rather unusual about this, at least that I believe back in February, they decided to kick some of the cases, but not all. And, trying to read the court, I know, is always a very difficult thing until they actually tell you what's going on. They release opinions or cert grants. But the assumption seemed to be that the reason they were doing that is they kicked some, they were holding the others, they were going to grant cert on those, and then we would have Supreme Court cases on those in the future. And on Monday, they did not grant cert on any of them. I'm curious, were you surprised by that? And what do you think is the reasoning for, I know it's dangerous to try to read the minds of the Supreme Court, but what do you think is the reasoning for why they did that? And does it have to do with what we're seeing right now in the legislature, that even creaky as Congress is, that the wheels are actually turning?
Yeah, it's a great question. So the first thing to say is the process by which the US Supreme Court decides which cases to take and which cases not to take is one of the darkest and blackest boxes in all of American politics. So no one knows for sure, but I'm happy to speculate. You are exactly right. And I've been a constitutional litigator and a Supreme Court litigator for 20 years. I've never seen anything like this. Just to set the stage, the Supreme Court is a court of what we call discretionary jurisdiction. Almost all of the cases that come before the Supreme Court, they have the decision whether or not to take the case. They get about 10,000 applications to take cases a year, and they take about 60 or 65. So it's a tiny, tiny fraction of the cases that are brought to them. Do they decide, yes, we will get involved in that case, or we'll get involved in this issue? Over the period of the last year, the Supreme Court handled its docket in such a way that at one time they had 13 different qualified immunity cert petitions. A cert petition is the application that you file to ask the court to take your case. And they had arranged it in such a way that these cases kept piling up. The first one was a case called Baxter v. Bracey out of the Sixth Circuit involving a police pursuit and dog bite out of Tennessee. That one was ready to be heard back in May of last year, and they held it, and they didn't decide whether or not to take it. And then as time went by, more cases kept coming in, and they kept kicking the can down the road, like you described. And so essentially what happened was they kept, it was very clear that qualified immunity was on their radar screen because none of this happens by accident. And you have these cases piling up. And on Monday, what happened was we found out that the Supreme Court had decided not to take any of these qualified immunity cases, which in some sense was surprising, because why on earth would you hold on to all these cert petitions involving qualified immunity if you don't plan to get involved in the issue? It'd be easier to just, as they become ripe, that's what we say, ripe is a word that describes when you're ready to make a decision. And some of these cases, as I said, were ripe for over a year. Just say no. So something was going on. Very clearly. Now, what explains why they held on to these cases for so long, only to turn all of them away? My surmise, and it's only a surmise, is that they were paying attention to what was happening across the street in Congress. And it seems to me that the most likely explanation is that the Supreme Court looks over at Capitol Hill, sees that Congress seems to be fairly serious about doing some sort of a global police reform effort, and says to themselves, well, look, we don't want to be in the position of, let's imagine, metaphorically, that you're trying to land an airplane. We don't want to be in a position where both the pilot and the co-pilot are struggling for control, of the landing gear at the same time. Let's step back, let Congress take the first crack at this and see what happens. I think that's probably what they had in mind. And they just felt like, look, we don't want to be working on qualified immunity at the same time that Congress is working on the larger issue of police reform. We know it's on their radar screen too. Let's see what they come up with. And if there's something left for us to do when the dust settles, then we can take a fresh look at it. That's my best guess as to what happened. But it was very disappointing because, again, the Supreme Court created this mess. Keep in mind what I said at the beginning. Qualified immunity doesn't have a shred of textual or historical or originalist legitimacy. In fact, Justice Thomas actually wrote a dissent from the denial of cert on one of these cases in which he said that basically that exact same thing, that like, look, we created this mess by misinterpreting a congressionally enacted statute, and we shouldn't be trying to play, I'm somewhat expanding on his, I'm reading between the lines here, but like, we shouldn't be trying to play 3 or 4 or 5 dimensional chess and, or make an 8 cushion bank shot. We messed up. We created a mess by misinterpreting the statute. It is incumbent upon us to fix what we broke. And then if Congress wants to go from there, that's up to them. As you can probably tell from the way I'm describing it, if that is in fact what Justice Thomas had in mind, what I'm attributing to him, I emphatically agree with it. The U.S. Supreme Court created the qualified immunity mess. What they should have done was fix what they broke, clean it up, get rid of qualified immunity, which doesn't have a shred of legitimacy whatsoever, and then let Congress decide what kind of policy making they want to do on a clean playing field that doesn't contain all of this detritus from the complete, screw up that the Supreme Court created or engaged in about 40 years ago when they sort of brought the qualified immunity doctrine into its modern form.
So we've got a lot of great questions in the queue. We're going to get to those in just a minute. I have one more question for you, Clark. So, one of the lessons I've learned in life is that there are no unalloyed goods, and that any action that you're going to take is going to have consequences, both the positive ones that you can foresee and often positive ones you can't, and negative ones that you can perhaps foresee and often ones you can't.
Right.
In your opinion, if we were to completely get rid of qualified immunity, as you have discussed, what do you think could potentially be the drawbacks of doing so? Or at least what are the problems that would be created by doing so that thoughtful people would need to be ready to address? I guess in a form like what is, or perhaps another way to address it, what is the best argument the other side has for keeping qualified immunity, whichever way you'd like to approach that?
Right. Yeah, it's a very fair question. I'm glad that you asked it. Look, police and other government officials sometimes find themselves in genuinely gray areas. And I want to say something that I think we all need to understand and respect. We ask police officers, in fact, we we order police officers to go into situations that they have no business going into. We use the criminal justice system, and of course the police are kind of the sharp end of the criminal justice spear. We use the criminal justice system for so many things that it is not useful for. We use it to address issues of mental health, of substance abuse, of poverty. The list goes on and on. We are constantly putting police officers in positions where they don't belong, where they're not well equipped, either sort of materially or psychologically or professionally for what we're asking them to do. And so we are frequently putting police and other government officials in positions that we shouldn't be. And to insist that they get it right, perfectly right every time is not fair. I think there's no dispute about that. So if we're going to insist upon police going into situations where they have no business, and let's just be really frank about it, doing violence to people who haven't done anything morally wrong. And a huge chunk of the US criminal code involves criminalizing conduct that is not actually wrongful, but it still has to be enforced. So we're routinely putting police in the position where they're doing violence to people who haven't really done anything wrong. Well, that's a hell of a position to put somebody in, right? And for that person to then turn around and say, look, if you're gonna put me in that position, I want a bit of a buffer, that's not a wholly unreasonable position to take, I think. Now, I think the way it's actually implemented, the way it actually works out in real life is utterly unreasonable, completely indefensible as a matter of policy. And then on top of that, there's the fact that it's not even a policy that's the one that the policy making branch itself came up with. Again, this is a policy that was invented out of whole cloth by the Supreme Court, engaging in an act of completely illegitimate, and I should add, tragically misguided policy making. So can you defend sort of some aspect of qualified immunity on the merits? Yeah, you can. Is it a good policy? No. Is it a legitimate policy? No. Should we get rid of it and start from scratch? Absolutely. It's not even a close call. It's a no-brainer.
We go to the questions. Tyler wanted to, and again, we want to remind people, if you have questions, you can enter them in the question and answer function in the Zoom call here. Tyler, why don't you take the first one here?
Absolutely. Thanks, Eric. From an anonymous attendee, a friend, a 25-year veteran, retired in the late 90s. He had never heard of qualified immunity. What do police officers learn about qualified immunity when going through training?
I don't know. I mean, I've not been through that training. It'd be presumptuous of me to suggest that I know. It seems reasonably clear to me that either during their initial training and or during their sort of on-the-job training, there is certainly some discussion of the conditions or the circumstances under which you as a police officer can be held liable. So I know it's something that is on their minds. My guess, just based on my experience in this area, is that it varies wildly. My guess is that in some departments there's there's probably a significant amount of misinformation. I see that constantly, by the way. It's amazing how much misinformation the law enforcement community engages in when it comes to qualified immunity. I'll just take one example. I can't tell you the number of times in the last couple of weeks I have had people tell me, I was just talking to a police officer, or I was just talking to a representative from the law enforcement community who said if we get rid of qualified immunity, it will expose individual police officers to ruinous personal liability. And there's a lot of responses to that, but I'll just give you one. There was a study by Joanna Schwartz, who's a UCLA law professor. She wrote an article in the NYU Law Review in 2014. She did an empirical survey to determine how often do individual police officers actually have to pay out of their own pockets when they engage in misconduct, and there's either a damages award or a settlement because of their misconduct. And the answer is this. In 99.98% of cases, or more precisely, 99.98% of all dollars paid out as a result of civil rights lawsuits because of police misconduct are paid not by the police officer, but by their employer. That means the department or the city. And what it really means is by us, the taxpayer. So when you hear a member of law enforcement or a police officer saying, oh, without qualified immunity, I could lose my house or my retirement fund or whatever, that is a complete fabrication. Police are almost never held individually liable, or when they are held individually liable, they never pay out of their own pockets except for 0.02% of the time. And the maximum amount that any police officer ends up contributing to a damages award is usually not more than a few $100. So that's an example of a piece of misinformation that is very common, but just doesn't have any basis in truth. So if we were to change the policy, there would not be this intolerable exposure that police officers tell us that they would face. It just wouldn't happen.
Before we go on to the next question, I want to follow up on that. So if we end qualified immunity, to what extent does that open up us as the taxpayer to, future financial burdens for successful lawsuits claiming that police officers have deprived someone of their rights? There is a payment, there's a judgment to be paid out there. And of course, it's paid, as you said, out of the coffers of police departments, out of city police departments, possibly out of state police departments, the revenue for which all entirely comes from us, the citizens.
Right. So keep this in mind. We are the employers. They work for us. And at least in theory, we have the right to and the power to set the terms and conditions of that employment. And I've proposed, and others have proposed, but it's interesting. I came up with this without seeing that other people had thought of this as well. But when, multiple people come up with a similar proposal, it suggests that maybe it's worth a look. We could change this overnight. You know what we could do? We could simply say to police officers, look, like other professionals, like every other professional, you need to have your own professional liability insurance. We are not going to pick up the tab for your misconduct anymore, but we don't expect you to expose yourself to ruinous financial liability. Instead, here's what we'll do. We will give you an allowance with which you can go and purchase professional liability insurance. And guess where we'd get that money from? We would get the money for the allowance out of the dollars that are currently being paid out in civil rights awards or civil rights damages. So we take some of that money that we're currently throwing away, indemnifying police officers who've injured people through their own misconduct. And instead of paying out through indemnity, we turn around and we say to the police officer, look, here's an allowance. Go get yourself some professional liability insurance. And here's why that would be such a great policy. Just like with a good driver, police officers who do not generate significant damages claims would see the cost of their insurance policy come down. I would let them keep the difference. Here's how much your allowance is. Here's how much your insurance policy actually costs. You keep the difference because you're a good cop. Flip side, these small handful of bad apples we're constantly hearing about, what do you think would happen to the cost of their insurance? It would go up, just like a bad driver. And we would not give them an additional amount of allowance. They would pay the extra amount out of their own pocket. Because why? Because it was their misconduct that caused the cost of their policy to go up. And as the cost of that policy goes up, the really bad ones would find that they would become uninsurable and therefore unemployable. And what could be better than that? So there are an incredible number of public policy responses that we could turn to that would result in us not being on the hook, that would result in the worst police officers no longer being able to work in the vocation. And why don't we do it? Because qualified immunity removes the pressure to investigate and implement better policies than the ones we have now.
It's interesting. It's almost as if incentives matter. But Shailesh, who regular attendee of AF events in Chicago, asked a question that is very similar to what you just addressed. So I'm going to give it anyway because I think there's a part on the end that you be able to address as well. Do you see municipalities buying malpractice insurance for all officers? Else, isn't this going to diminish the recruiting pool for police officers? Atlanta officers already calling in sick because of the DA's charge of second-degree murder against the police officer from this past weekend. Wouldn't curbing police unions be a better answer?
Well, listen, I mean, I sort of view a lot of what's going on in the criminal justice space, including our culture of policing, as kind of like a cancer, right? And if somebody were to tell you, well, I think that radiation would be better than chemotherapy, I'm like, I think maybe everything should be on the table, right? So is there a problem with police union contracts? Yeah, of course there is. It turns out that's pretty hard. You don't wave a magic wand and make that go away. Ending qualified immunity is a rifle shot response to a lot of problems in the system. Either Congress or the Supreme Court could get rid of it tomorrow. The same is not true of these incredibly pro-police and often quite perverse union negotiated employment contracts. If anybody thinks they have a rifle shot solution to the problem of endlessly favorable pro-police union negotiated contracts, I would love to see it because I've been thinking about it a lot and I don't know of any kind of sort of rifle shot solution like we have with qualified immunity. Would I like to see us get rid of them? Yeah, absolutely I would. Do I know how to do it? No, not at all. And I've never met anybody who knows how to do it. But is it something that's desperately in need of reform? Absolutely it is. And there are plenty of people doing great work on that. It just happens to not be where my focus is, simply because I think that's going to be more of a kind of a battle of attrition. I think there are other organizations besides the one I work for, which is the Cato Institute, that are better equipped to engage in a kind of a grinded out war of attrition with public employee unions. That's not something I'm equipped to do, but I take my hat off to people who are doing it, because it's a hard fight and it's an important fight.
Thank you. And I want to remind everyone, please, if you have any more questions, keep them rolling in. We've got plenty to work through now, but we still do have some time. So if you have any questions you want answered, please send them in. This sort of builds on something that you just spoke on. What can be done at the local and state level to eliminate or weaken qualified immunity? Or are we completely dependent on federal reform efforts, whether through Congress or the Supreme Court?
You know, I think I have two responses to that. One is sort of just objective and factual, and the other one is more practical. Objectively, it actually would be quite straightforward. What a lot of people don't realize is qualified immunity is a personal defense. It is up to the individual police officer whether to assert that defense in a civil rights lawsuit. And actually, there are times when police could have asserted it but didn't. Now, whether it just didn't occur to their lawyers or whether there was some other consideration, I don't know. But there actually are cases where they could have asserted qualified immunity as a defense to a civil action and didn't. So we could easily have a situation where, as a department, you make it a requirement, a condition of employment, that you are not permitted to assert the defense of qualified immunity. Is it available to you as a matter of law? Yes, it is. Do you have the ability to negotiate a contract in which you say, but nevertheless, I will not assert it? Yes, you do. I haven't heard of anybody doing that. I'm not aware of any department that has proposed it, but could we do it? Absolutely. It would be perfectly legal, and I think actually really good policy. Now, in the world of practical politics, do I expect to see that happen? No, I do not. Why? Because again, the law enforcement lobby is one of the second or third strongest in the country, and arguably their number one issue is ensuring the absolute minimum level of accountability for their members that they can, and they would never sit still. I would guess, my surmise is that they would never sit still for a department that made as a condition of employment that police officers agreed to not assert the personal defense of qualified immunity in civil rights cases. I want to say one last thing. It's been in the air the last couple of questions we've had that, oh, what effect will this have on police recruiting? My answer to that is a virtuous effect. If there are people out there who are currently interested in being police officers who would suddenly get a lot less interested if they had to agree to be held to the same level of accountability as the rest of us, then they shouldn't be cops. They go find other work. They can go find something else to do. If they're not interested in accountability, then they shouldn't be interested in a career in law enforcement.
So I want to bring it back to the union question. And so we have a question here in the queue asking about why would the Democratic Party as a whole be hesitant to support eliminating qualified immunity? And I think we've seen from some of the political machinations so far that they seem to be on board with it. But to bring it back to the union point, what has struck me as interesting in this is you mentioned the power that the lobby has. And I've lived in Chicago for quite a long time. I know how powerful the FOP is in the city of Chicago. What's interesting to me about this moment and is interesting about that history is the way that it is a public sector union that has gotten both political parties on board with it. Generally speaking, and I admit I'm generalizing here, so apologies to everybody with more nuanced opinions out there, Republicans on board because they're supportive of law enforcement, and Democrats on board because they're supportive of public sector unions in a way that, you know, teachers unions or so many of the other public sector unions do not enjoy the same kind of bipartisan support. Do you expect, and I think you've already answered this, but I'll tee it up to you again and perhaps invite you to engage in some rank punditry that you are more than welcome to decline to engage in. Is there anything that you can think that can shake that monopoly that they seem to have on both political parties? Are we in a moment in time because of what we've seen happen with George Floyd, with Breonna Taylor, with Ahmaud Arbery, even though that was not a police-involved incident, but all of these that have contributed to the conversation that we're having right now? Are we in a moment that we can shake loose that tradition and the political hold that police unions have had on both political parties could be weakened, perhaps down to one, or perhaps shaken, you know, at least the grip is loosened a little on both of them?
Yeah, great question. I'm gonna indulge myself in a metaphor because I love metaphors. Let me give you an image. Let me give you an image of a lifeboat with 10 or a dozen people in it, out on the the vast ocean. with no prospect of being rescued immediately, and they have limited supplies. Now imagine that there's one person in that lifeboat that refuses to participate in rationing. That person drinks whenever he's thirsty and he eats whenever he's hungry. If there comes a point where one person has to get thrown off the lifeboat, who do you think is going to get thrown off? And what I see happening right now is that the public employee unions are starting to look at the police unions as if they're that one person on the lifeboat, right? That if it's necessary in order for the rest of us to survive that somebody goes overboard, we know who's going overboard. Now, whether that'll happen or not, I'm not sure, but it is certainly clear that the police unions have engaged in the most high profile and indefensible kind of misconduct, right? Because they constantly defend officers who've done the indefensible. They insist upon this near zero accountability. They misrepresent things like, for example, that if we get rid of qualified immunity, then individual officers will be exposed to ruinous personal liability, when we know that's completely and demonstrably false. And so they've engaged in this kind of unending amount of bad behavior. Let me give you one more example, by the way, of a very common police union negotiated provision. For example, if you were to kill somebody, or you were engaged in, let's say that you were present when somebody was killed violently, you would be questioned immediately by the police, and your failure to be forthcoming in your answers or to lawyer up would be considered very suspicious. Do you know what happens if a police officer is engaged or kills somebody? In many municipalities with a police union negotiated contract, that police officer cannot be questioned for days until they've had a chance to talk to their partners, whoever was on the scene, talk to a lawyer, talk to a union representative. You know what else they get? In some cities, they even get access to all of the evidence that has been gathered at the scene. They will get to watch videos, they'll get to see witness statements, they'll get to find out every single thing that the internal affairs and other people know before they have to give a statement. Can you imagine that same largesse being extended to an ordinary citizen? And yet when cops are accused of engaging in the excessive use of force or even killing somebody, they get all of these benefits. They get days and all of the information with which to tailor their story about what happened to what they know that the government can prove if it comes time to charge them with a crime. That is just an example of the many, many ways in which police unions are successful in negotiating and working into the system these double standards that result in police being held to an extraordinarily low level of accountability while the rest of us are held to a high level of accountability. That, in the end, is utterly defensible. And if push comes to shove, do I think that other public employee unions are prepared to throw police unions out of the lifeboat in order to save themselves? Yeah, I do.
Yeah, thank you very much for that. I wanted to bring something back to happen in Grand Rapids in 2014. As you mentioned, qualified immunity has been on the books for a long time. It's been a problem institutionally for police departments around the country for a long time. But 6 years ago in Grand Rapids, a man named James King, who was a college student at the time, was, I'm quoting directly from an IJ brief, brutally beaten and choked unconscious by members of a joint state federal police task force after they misidentified him as a suspect sought in connection with a nonviolent petty crime. It's been held up in courts for 6 years now, and it's still going on. One of the things they're doing is calling into question qualified immunity to try to prevent the prosecutorial action on this. But they're also talking about the nature of overlapping jurisdiction given a joint federal state task force. Is there anything that plays into qualified immunity with overlapping jurisdictions like that?
Yes and no. So qualified immunity is a defense that is available both to federal law enforcement officers and to state law enforcement officers. So it applies to both populations. I think the real takeaway, so by the way, all props to IJ for that case. You should really go online if you haven't, and there are photographs of what that guy looked like after they were done with him. And this is something that I want to emphasize just really quickly. One of the things that's so grotesque and horrifying about this is when you see descriptions of the injuries that are sustained by people who've been the victims of police violence, they don't look like what you see in a normal fight. They are not the kinds of injuries that one human being normally inflicts on the other. When people have been the victims of police violence, they look like their injuries look like they've been in a car wreck or an industrial accident. I'm talking about like crushed orbits, you know, like they've crushed your the bones around your eyeballs, a nose that's been moved from one side of your face to the other. It's astonishing the amount of violence that is visited upon people who resist police. But going back to this case, one of the things that's amazing about that IJ case is that, not amazing, instead of amazing, it's perfectly routine, but it drives home a point that if you've been in this business long enough, you'll see it every time. Government defendants are extraordinarily adept at deploying the most shameless defenses. And what they've done in this case is as you said, it's a joint task force. There was both a local Grand Rapids police officer and there was also, I believe, an FBI agent, but there was or Homeland Security agent. So there was a federal agent and there was a local officer. And what you'll see them do is whenever it's to their benefit to characterize that team as local, because it helps them in some way legally, then it was a local team. But whenever it's to their benefit to characterize that team as a federal team that was closed with federal authority, then they assert that. And they're absolutely shameless throughout this litigation in flip-flopping back and forth and saying, essentially they're like, they're these kind of two-faced weasels that whenever they just look at the situation, they say, well, whatever would be most legally beneficial to us, that's what we were. And they change their story every time a new brief is filed, every time a new legal issue comes up. And currently the case is pending review in the Supreme Court because the federal government is arguing that essentially because a particular aspect of the case got thrown out, then the entire case should be thrown out. And it really, I think, underscores this approach that I've seen time and time again as a career constitutional litigator and a public interest lawyer, which is that the basic mindset of the government in litigation against citizens is heads we win, tails we lose, screw you, you don't belong in court, we never did anything wrong.
Time for one more audience question. I'm going to go this one from William. What do you think the elimination of qualified immunity, what effect do you think it would have on addressing the blue wall of silence that happens? I mean, being in Chicago and having witnessed particularly the Laquan McDonald case over the last few years and numerous other cases where even if there are other officers present who think something has gone wrong, they don't say anything about it. Do you think changing or ending qualified immunity would have any impact on that element of police culture?
I'm going to take a moment to editorialize, if I may, and get something off my chest. I'm pretty active on Twitter, and my handle is Con Law Warrior, all one word. And one of the things that's so amazing to me interacting with people on Twitter is the number of people who are absolutely certain that they know exactly what will happen if we qualified immunity. I'm not going to join those ranks because I actually don't think I know exactly what will happen. I have a pretty strong sense that some virtuous things will happen and that qualified immunity on balance is a pretty bad policy and that things are likely to improve. So I'm going to offer a surmise. And I'm going to preface it that way by saying it is only a surmise. I think that the culture of kind of mutual support within law enforcement, what's sometimes described as the blue wall of silence, is so robust that the elimination of qualified immunity would be unlikely to have very much effect on it. I've talked to so many police officers who have told me that if you don't go along with whatever your partner says, even if they're completely lying about the way that an event went down, your career in law enforcement will be short, unhappy, and very dangerous because they're not going to come to your aid when you need it. That seems to, and I've never heard any police officer dispute that. What I think could happen though, so I don't think it will necessarily have a significant impact on the blue wall of silence, so-called, which is a thing. What I think it might do is to reduce the number of officers in the profession who trigger the blue wall of silence. In other words, it'll reduce that number of proverbial bad apples. I think police will still go to bat for each other. They'll still lie for each other like they do now, but the number of times when they have to do it will be reduced. Why? Because the number of police officers who are unfit for the job will also be reduced. I think qualified immunity will have the virtuous effect of hounding out of the vocation at least some of the bad apples who don't belong in the vocation. And so the sheer number of times when supposedly good police officers have to go to bat for demonstrably bad police officers hopefully will be diminished. And I want to add one last thing that was one of the best things I've seen on Twitter in the last few months, which I know is a very low bar. But someone said the following, which I think is just brilliant. If you have 10 police officers who routinely violate people's rights and 1,000 police officers who never violate people's rights, but also never restrain the other ones, then you know what you have? You have 1,010 bad officers. That's what you have.
Thank you so much, Clark. And I do have one quick question before we close out. We've talked a lot tonight about a very complex issue. Is there a place where people can find more resources on qualified immunity and further reform efforts?
There is. The Cato Institute has created the single most informative website on the internet for everything qualified immunity. And it's amazing because it's a very rich resource, but it's also incredibly accessible and it's really easy to find. It's unlawfulshield.com. Unlawful shield. In fact, if you just Google unlawful shield, which you should be able to remember because that's what qualified immunity is, just Google unlawful shield and you'll find it. And we have a whole website. It's got case descriptions. It's got an FAQ that tells you everything about qualified immunity, including where it came from, how it works. And we have a blog that we keep current that tells you everything that's going on with qualified immunity that you might want to know about. So go to unlawfulshield.com and you will be an expert overnight in qualified immunity, which you really should be.
Clark Neily, Vice President of Criminal Justice at the Cato Institute. Clark, thank you so much for joining us this evening. Before we go, a couple of quick housekeeping notes. Want to thank everybody who joined tonight to listen to this conversation. We think it's really important, and it is part of an ongoing criminal justice reform series that America's Future Foundation is having this month. This is only part 2. Clark, thank you so much for joining us this evening. We really appreciate your time. For Tyler and AF Grand Rapids, I'm Eric Cohn with AF Chicago. Thanks so much for joining us this evening.
Thanks, everyone. Good night.
Night.